Welcome back to HOA Spot. The gate hinge was in my hand and the fine was in her mouth. Karen demanded I move the stakes and yelled that if I touched them wrong it would be tampering. "You are about to get added to the agenda," she said, jabbing one finger toward the string line the surveyor had just stretched across my yard. I stood there holding the small bag of screws in my pocket, feeling the metal edges press into my palm, and I said nothing, because silence makes people talk. She kept going, her voice climbing, and I could see her hands shaking as she pointed at the orange survey stakes hammered into the dirt. "This is Bend, Oregon, and this is the Boundary Oaks HOA Board, and this is Tiffany Anderson, the Rules Enforcement Chair who loves warning letters more than most people love their own families. My fence was supposed to go up clean, 6 feet tall, pressure-treated pine, set back from the property line exactly where the surveyor marked it. I work rotating shifts as a firefighter, and I had been saving for months to get the fence installed because my backyard opens onto a busy street and I wanted some privacy and noise buffer. The contractor was supposed to start Monday, finish by Thursday, and I would finally have a yard that felt like mine. Tiffany had other plans. She showed up the morning the contractor arrived, holding a portable folding sign stand that read Warning Compliance Review in Progress in big block letters, and she planted it at the edge of my driveway like she owned the curb. The contractor looked at me, looked at her, and asked if this was going to be a problem. I told him no, just set the posts where the survey marks are and ignore her. He nodded, but I could see him glance back at Tiffany every few minutes while he worked. By noon, I had my first notice. It was taped to my front door, printed on Boundary Oaks letterhead, and it said the fence exceeded the maximum allowable height by 1 inch and violated setback requirements, and I had 72 hours to submit revised plans or face a $500 fine. I read it twice, standing on my porch with the sun beating down and the sound of the post-hole digger grinding away in the backyard, and I felt that cold weight drop into my stomach because I knew this was not about 1 inch. I called the surveyor. He came back out that afternoon, pulled his records, double-checked the measurements with a laser level, and confirmed that my fence was exactly 6 feet tall and set back 2 full feet from the property line, which was 3 inches more than the HOA rules required. He handed me a printed copy of his report with timestamps and photos, and he told me to keep it somewhere safe, because HOA disputes always escalate. I thanked him, paid his invoice, and walked back inside to find another notice taped to my door. This one said I was in violation of the construction notification policy because I had not submitted a 21-day advance notice before breaking ground, and the fine was now $750. I stood there staring at the paper, holding the survey report in my other hand, and I realized 2 things. First, I had submitted the advance notice 4 weeks ago, and I had the email confirmation saved in a folder on my desktop. Second, Tiffany was not trying to enforce the rules. She was trying to drown me in paperwork and fees until I gave up and tore the fence down myself. That night, I pulled up every email, every receipt, every photo I had taken during the planning process, and I started building a timeline. I work nights, so my sleep schedule is a disaster, but I stay organized because in my line of work, you learn fast that documentation saves lives. I had pictures of the property line from 3 different angles: the original fence proposal with the HOA approval stamp, the contractor invoice with the start date, and the email thread where I asked Tiffany directly if the setback was sufficient, and she replied yes, as long as you follow the guidelines in Section 4.2. I saved everything into a single folder, backed it up twice, and then I printed a hard copy because I knew she would try to claim I never submitted anything. The next morning, Tiffany showed up again, this time with a tape measure. She walked right up to the fence line, pulled the tape out with a loud snap, and started measuring the height of the posts. The contractor was there installing the top rail, and he stopped mid-swing with the hammer and asked her what she was doing. She ignored him, called out measurements to herself, and wrote them down on a clipboard with a pen that clicked over and over. I stepped outside, still holding my coffee, and asked if I could help her. She turned around, smiled the kind of smile that does not reach the eyes, and said, "If you make me repeat myself, it gets more expensive." I did not say anything. I just stood there and sipped my coffee while she measured every post, every rail, every board, and scribbled notes on her clipboard like she was conducting a forensic investigation. The contractor looked at me, shrugged, and went back to work. After 20 minutes, Tiffany packed up her tape measure, picked up her folding sign stand, moved it 3 feet closer to my driveway, and walked away without another word. That afternoon, I got a third notice. This one said the fence was installed without a licensed contractor verification form on file, and I was being fined $1,000 and required to halt all work immediately pending a compliance review hearing. I read it twice, checked the date, and realized she had mailed it before she even came out to measure the fence. The postmark was from yesterday. She had written the violation before she had any new evidence. I called the contractor. He confirmed he was licensed, bonded, and insured, and he offered to send me a copy of his credentials and a notarized letter stating that the fence met all local building codes. I thanked him, asked him to hold off on any more work until I got this sorted, and then I called a retired police officer who lives 2 doors down. His name is Ray, and he has lived in Boundary Oaks for 15 years, and he knows more about HOA enforcement than anyone I have ever met. I explained the situation, showed him the notices, and asked him what I should do. Ray looked at the timeline, looked at the postmark on the third notice, and whistled low. He said that is not enforcement, that is retaliation. He told me to file a formal records request with the HOA management company, ask for copies of every notice they sent me, every email they received from me, and every board meeting minute where my fence was discussed. He also told me to document every interaction with Tiffany, every time she moved that folding sign stand, every measurement she took, because eventually she would contradict herself and I would have proof. I filed the records request that night. I asked for everything going back 6 months, and I specified that I wanted certified copies with original timestamps. The management company replied 2 days later and said my request was approved, but I would need to pay $300 in copy fees and wait 30 days for processing. I stared at the email, felt my jaw tighten, and realized this was the second escalation step. They were stalling me, hoping I would either give up or miss a deadline and rack up more fines. I paid the fees, I set a calendar reminder for the 30-day mark, and I kept documenting. Every time Tiffany moved the folding sign stand, I took a picture with a timestamp. Every time a new notice appeared on my door, I photographed it in place before I touched it, then photographed the envelope, then scanned the contents. I started a spreadsheet with columns for date, notice type, stated violation, actual rule citation, and evidence proving I was in compliance. By the end of the first week, I had 14 rows of data and a growing sense that I was building something that could actually flip this. Meanwhile, the fence sat half-finished. The contractor called me and said he could not legally continue work if there was an active stop work order on file, even if the order was bogus. I told him I understood, and I would let him know as soon as I got it lifted. He said he would hold my spot in his schedule for 2 more weeks, but after that he would have to move on to other jobs. I thanked him, hung up, and stared at the fence posts, standing bare in my backyard like a row of gravestones. Tiffany must have noticed the work had stopped, because 2 days later she was back. This time she brought a clipboard, a digital camera, and a man in a white polo shirt who introduced himself as a compliance inspector. I asked him who he worked for. He said he was an independent contractor hired by the HOA to verify violations. I asked to see his credentials. He hesitated, glanced at Tiffany, and said he did not have them with him, but he could email me a copy later. I said that works, and I pulled out my phone and started recording video. He immediately stepped back, told Tiffany he needed to reschedule, and walked away. She glared at me, called after him that she would handle it, and then turned to me and said we can tow first and explain later. That is how enforcement works. I stared at her. I said I do not have a car parked illegally, and my fence is not blocking access to anything. She smiled, tapped her clipboard, and said you would be surprised what counts as a violation once we review the rules. Then she walked away, folding sign stand under one arm, and I stood there replaying her words in my head because they sounded like a threat, and I wanted to make sure I had not misunderstood. That night, I got an email from the HOA management company. It said a formal compliance hearing had been scheduled for 2 weeks from today, and I was required to attend in person and present evidence that my fence met all rules, or the board would vote to impose a lien on my property and require immediate removal of all non-compliant structures. The email included a list of documents I needed to bring, including the contractor license verification form, the advance notice submission, the survey report, and proof of payment for all outstanding fines. I read the list twice and realized they were asking me to prove things they already had on file because I had submitted all of it weeks ago. I replied and asked them to confirm receipt of my original submissions. They responded 3 days later and said they had no record of receiving any advance notice or contractor verification, and if I could not provide duplicates, they would assume I had never filed them. I opened my email archive, pulled up the confirmation receipts, and forwarded them back with the subject line Records Request Follow-up. They did not reply. At this point, my insurance carrier was requesting photos of the fence for a property coverage update, and I had to respond within a short window or risk my policy lapsing. I took pictures of the half-finished fence, the survey stakes still in the ground, the disturbed dirt around the post holes, and the folding sign stand that Tiffany had left parked at the edge of my driveway for 3 straight days. I uploaded everything to the insurance portal, hit submit, and watched the progress bar crawl forward. It stalled at 94%. I refreshed the page, the upload failed. I tried again, same result. I checked my internet connection, it was fine. I tried uploading from my phone, same failure. I realized the HOA portal uploads were mysteriously failing right when the deadline hit, and I felt that cold weight in my stomach again because this was too convenient to be an accident. I called my insurance agent, explained the situation, and asked if I could email the photos directly instead of using the portal. She said yes, and she made a note in my file that the HOA portal was malfunctioning. I sent the photos as attachments, got a confirmation reply, and crossed that deadline off my list. 1 problem solved, 50 more to go. The hearing was now 10 days away. I spent every spare hour reviewing the rules, cross-referencing my timeline, and rehearsing what I would say. Ray stopped by one evening and offered to come with me as a witness. He said he had attended dozens of HOA hearings over the years, and he knew how Tiffany operated. She would try to control the narrative, interrupt anyone who disagreed with her, and pressure the other board members to vote her way before anyone had a chance to review the evidence. He told me the key was to stay calm, speak in facts, and force everything into the meeting minutes so there was a permanent record. I asked him what he meant by force everything into the minutes. He said, any time you present evidence, you say, I am submitting this document for the record, and I request that it be read into the minutes. That way, even if the board ignores it during the meeting, it becomes part of the official record and you can reference it later if you need to appeal or file a complaint with the state. I thanked him, wrote that phrase down on a notepad, and taped it to my desk where I could see it every day. 3 days before the hearing, I got a call from the contractor. He said Tiffany had contacted him directly and told him that if he continued working on my property after the hearing, she would file a complaint with the state licensing board accusing him of performing unpermitted work. He was furious, but he was also scared because a complaint like that could tie up his business for months, even if it was baseless. I told him to ignore her, that I had documentation proving the work was permitted and compliant, and that I would handle her at the hearing. He said he appreciated it, but he was not sure he could risk it. I understood. I told him to hold off until after the hearing, and we would figure it out from there. That was the moment I realized Tiffany was not just targeting me, she was targeting anyone who helped me. The surveyor, the contractor, even Ray if she found out he was coming to the hearing. This was not about rules. This was about power, and she was willing to burn through vendors, neighbors, and documentation standards to keep it. If you are enjoying this story and want to see how I turn the tables on Tiffany, hit that like button and subscribe so you do not miss what happens next. 2 days before the hearing, I received the records package I had requested. It arrived in a padded envelope with a delivery confirmation signature required, and when I opened it, I found exactly 3 pages. One was a cover letter from the management company. One was a copy of the original fence proposal I had submitted. One was a blank page. I checked the invoice stapled to the envelope. I had paid $300 for 3 pages, one of which was blank. I called the management company immediately. I explained that the request had specified 6 months of notices, emails, and meeting minutes, and I had received almost nothing. The woman on the phone said, "That is everything we have on file for your address." I asked her to confirm that there were no notices sent to me in the past 6 weeks. She said, "Hold on," clicked through something on her computer, and then said, "We show multiple notices sent to your address, but those are not part of the records request because they were generated after you filed the request." I asked her how that made any sense. She said, "If you want those records, you need to file a new request." I hung up, sat down at my desk, and started drafting a formal complaint to the state HOA ombudsman. Ray called me that evening. He said he had just heard from another neighbor that Tiffany had been going door to door collecting signatures on a petition to support the enforcement action against my fence. The petition claimed that my fence was an eyesore, a safety hazard, and a violation of neighborhood character, and it asked the board to impose the maximum fines and force immediate removal. Ray said at least 4 neighbors had signed it, including one who lived 3 streets away and could not even see my property from his house. He told me to get a copy of that petition if I could, because it would prove Tiffany was manufacturing community support. I asked him how I could get a copy. He said file another records request asking for any petitions or signed complaints related to your address. They have to provide it if it was submitted to the board. I added it to my list, filed the request that night, and braced for another round of stalling and fees. To my surprise, the management company replied the next morning and said the petition had been submitted as part of the hearing packet, and I could pick up a copy at the clubhouse office before the hearing. I drove over, signed for the packet, and opened it in my car. The petition was 4 pages long. Tiffany had printed it on Boundary Oak's letterhead, written a paragraph at the top describing my fence as a hazard and a blight, and included signature lines for 20 residents. 13 people had signed. I recognized 3 names from my street. The rest were from other parts of the neighborhood, and I was willing to bet half of them had no idea what they were signing. But what caught my eye was the date at the top of the petition. It was dated 5 days before the contractor started work. Tiffany had been planning this enforcement action before I even broke ground. I took a picture of every page, forwarded the images to Ray, and drove home. That night, I could not sleep. I kept thinking about the timeline, the postmarked notices, the backdated petition, and the way Tiffany had shown up the morning the contractor arrived, like she had been waiting for it. I pulled up my email archive and started searching for any messages I might have missed. I found one from 6 weeks ago, addressed to the full HOA board, where I had asked if there were any objections to my fence proposal before I hired the contractor. Tiffany had replied directly, and her email said no objections as long as you follow Section 4.2 setback requirements. I had that email saved. I had printed it. I had it in my hearing packet. And now I had proof that she had approved my plan in writing before she started issuing violations. I leaned back in my chair and smiled, because I finally understood what my trump card was. Tiffany had created a paper trail that contradicted itself. The petition was dated before construction started. Her approval email was sent after I submitted the proposal. The notices she issued cited violations that did not exist according to the survey report. And the management company had no record of my advance notice, even though I had a confirmation receipt. If I could get all of that into the meeting minutes, I could force the board to acknowledge that this was not a legitimate enforcement action. It was retaliation, and it was built on fabricated evidence. The hearing was scheduled for 7 in the evening at the clubhouse community room. I arrived at 6:30 with Ray, carrying a banker box full of documents, printed timelines, and highlighted rule citations. Tiffany was already there, setting up a projector and arranging folders on the table at the front of the room. The other board members trickled in over the next 20 minutes. There were 5 total, including Tiffany. The president was a man in his 60s who looked like he would rather be anywhere else. The treasurer was a woman who kept checking her phone. The secretary was taking notes on a laptop. The other member, a younger guy in a polo shirt, sat in the back and did not say much. At 7, the president called the meeting to order and asked if there was any old business. Tiffany immediately stood up and said she wanted to move my hearing to the top of the agenda because it was time sensitive. The president looked at the agenda, shrugged, and said, "Fine, we can do that." Ray leaned over and whispered, "That is a power move. She does not want you to have time to prepare." I whispered back, "I am already prepared." Tiffany pulled up a slide on the projector. It was a photo of my fence, taken from an angle that made the posts look crooked and uneven. She pointed at the screen and said, "This fence is 6 feet 1 inch tall, which exceeds the maximum allowable height by 1 inch. It is also set back only 18 inches from the property line, which is 3 inches short of the required 2-foot setback. The contractor did not submit a licensed verification form, and the homeowner did not submit an advance notice. This is a clear violation of multiple rules, and I am recommending immediate removal and a fine of $3,000. I raised my hand. The president nodded at me. I stood up, opened my banker box, and pulled out the survey report. I said, "I am submitting this document for the record, and I request that it be read into the minutes." The secretary looked up from her laptop. I handed her the report. She scanned the first page, looked at Tiffany, and said, "This shows the fence is exactly 6 feet tall and set back 24 inches from the property line." Tiffany frowned and said, "I measured it myself. That survey is incorrect." I pulled out a second document, the laser level certification from the surveyor, and handed it to the secretary. I said, "I am also submitting this certification for the record. The surveyor used a calibrated laser level and confirmed all measurements. The fence is compliant. Tiffany turned to the projector, clicked to the next slide, and showed another photo of my fence. This one was zoomed in on a single post, and she had drawn a red line across it with a measurement annotation. She said, "You can see here that the post clearly exceeds 6 feet." I pulled out my phone, opened the photo metadata, and said, "That image is edited." The red line was added digitally after the photo was taken. I have the original version here if you would like to compare. The treasurer sat up straight. She said, "Can we see that?" I handed her my phone. She looked at the screen, looked at Tiffany, and said, "This does not match." Tiffany snapped, "The measurements are accurate. I do not care what the metadata says." I turned to the president and said, "I am requesting that the board review the original photo files submitted by the enforcement chair and compare them to my documentation. If there are discrepancies, I believe that raises serious questions about the validity of this violation." The president looked uncomfortable. He said, "We can table that for now and move on to the advance notice issue." I pulled out the email confirmation receipt. I handed it to the secretary. I said I submitted the advance notice on August 2nd, 4 weeks before construction started. Here is the confirmation from the HOA management portal. The secretary read it, nodded, and said, "This confirms receipt." Tiffany shook her head and said, "We never received it. The portal must have failed." I pulled out a second printout, this time the email where Tiffany herself had replied to my fence proposal and said there were no objections. I handed it to the secretary. I said, "I am submitting this email for the record." The enforcement chair approved my fence plan in writing on August 5th. If there was a problem with the advance notice, why did she approve the plan 3 days after I submitted it? The room went quiet. The secretary looked at the email, looked at Tiffany, and said, "This email is addressed to the full board." Tiffany said I was responding to his proposal, not his notice. Those are two different things. I said then, "Why does the email say no objections as long as you follow Section 4.2 setback requirements? That sounds like an approval to me." The president rubbed his forehead. He said, "Can we just get to the contractor verification issue?" I pulled out the contractor license certificate, the notarized compliance letter, and the invoice showing the contractor was licensed, bonded, and insured. I handed all three to the secretary. I said, "I am submitting these documents for the record. The contractor is fully licensed, and the work meets all local building codes." Tiffany said the issue is not whether he is licensed. The issue is whether he submitted the verification form to the HOA before starting work. I said he did. I have the submission confirmation here. I handed her a fourth document, the email where the contractor had copied me on his verification form submission to the HOA management email address. Tiffany stared at it, her face going red. She said that is not the correct submission process. He should have mailed a hard copy. I said, "Show me the rule that requires a hard copy." She opened her binder, flipped through pages, and did not answer. Ray stood up. He said, "I am a resident and I am here as a witness. I would like to submit a formal objection to this enforcement action." He pulled out a printed timeline showing every notice I had received, every postmark, and every contradiction. He handed it to the secretary. He said the enforcement chair issued a stop work notice before she even inspected the fence. The postmark proves it. She also circulated a petition opposing this fence 5 days before construction started. That suggests this enforcement action was planned in advance and is not based on a legitimate violation. The secretary looked at the timeline, looked at Tiffany, and said, Is this accurate?" Tiffany stood up, her voice rising. She said, "I am the rules enforcement chair, and I have the authority to issue notices based on reasonable suspicion of a violation. I do not need to wait for construction to finish if I have credible information that a violation is occurring. Ray said, "What credible information? The fence was not even built yet." Tiffany glared at him. She said, "I had reports from neighbors that the fence would be too tall." Ray said, "Which neighbors?" Tiffany hesitated. She said, "I do not have to disclose that." Ray said, "Actually, you do if you are using those reports as the basis for an enforcement action." The president held up his hand. He said, "Everyone calm down. Let us take a vote on whether to proceed with this enforcement action or dismiss it and allow the homeowner to finish the fence." The treasurer said, "I move to dismiss." The younger board member in the back said, "I second." The president said, "All in favor." 3 hands went up. Tiffany did not move. The secretary raised her hand slowly, glanced at Tiffany, and said, "I abstain." The president said, "The motion passes. The enforcement action is dismissed, and all fines are rescinded. The homeowner may complete the fence as planned." I sat down, feeling the tension drain out of my shoulders. Tiffany gathered her folders, slammed them into her bag, and walked out of the room without another word. The folding sign stand was still sitting in the corner by the door. She left it there. Ray leaned over and whispered, "You just won, but she is not going to let this go." I nodded. I knew he was right. The next morning, I called the contractor and told him the stop work order was lifted. He said he could restart the following Monday. I thanked him, hung up, and walked outside to check the fence posts. They were still standing, weathered and waiting. I felt good. I felt like I had beaten the system. I should have known better. On Sunday afternoon, 2 days before the contractor was supposed to restart, I got a call from an unknown number. I answered. A man identified himself as a tow operator and said he was at my address to tow a vehicle for an HOA violation. I said I do not have a vehicle parked illegally. He said I have a work order from the Boundary Oaks HOA board stating that a vehicle at this address is blocking emergency access. I stepped outside. There was a flatbed tow truck idling in front of my house, and the driver was standing on the curb with a clipboard. I walked up to him and said, "Show me the work order." He handed me the clipboard. The work order was printed on Boundary Oaks letterhead, signed by Tiffany Anderson, and dated that morning. It said a vehicle at my address was parked in violation of fire lane access rules and required immediate removal. I looked at my driveway. My truck was parked in my own driveway, behind the garage door, exactly where it always was. I looked at the driver and said, "This is my driveway, on my property, and my vehicle is not blocking anything." He shrugged and said, "I just go where they tell me. I need to see proof that this vehicle is registered to this address, or I have to tow it." I pulled out my phone, opened my vehicle registration app, and showed him the digital copy. He looked at it, looked at the work order, and said, "This does not match. The work order says the vehicle is unregistered." I said, "That is a lie. Call your dispatch and verify." He looked uncomfortable. He said, "I can call, but if the HOA insists I still have to tow unless you can get a supervisor to override it." I said, "Call dispatch." He pulled out his phone, dialed, and put it on speaker. The dispatcher answered. The driver explained the situation. The dispatcher asked if the vehicle was on private property. The driver said yes. The dispatcher said, "Then we cannot tow without proof of abandonment or a court order." The driver said the HOA says it is a violation. The dispatcher said the HOA does not have the authority to order a tow from private property unless the vehicle is blocking a public access point. Is it blocking access? The driver looked at my driveway, looked at the street, and said no. The dispatcher said, "Then we are not towing. Cancel the work order and return to base." The driver hung up. He handed me the clipboard back and said, "You are good. Sorry for the confusion." He climbed into the truck, backed out of my driveway approach, and drove away. I stood there holding the work order, reading it again, and I realized Tiffany had tried to manufacture a new violation after losing the hearing. She had called a tow company, lied about my vehicle, and tried to have it towed from my own property. That was fraud. That was harassment. And that was a crime. I called Ray. I told him what happened. He said, "You need to file a police report immediately. What she just did is illegal, and you need it on record in case she tries it again." I drove to the Bend Police Department, filed a report, and handed over the fraudulent work order as evidence. The officer who took my statement said he would follow up with the HOA management company and with Tiffany directly, and if she had falsified the work order, she could face charges. I thanked him, got a case number, and drove home. That evening, I got a call from the HOA management company. The woman on the phone said the board president wanted to schedule an emergency meeting to discuss the tow incident and review enforcement procedures. She said the meeting would be held Tuesday night, and I was invited to attend. I said I would be there. I hung up, called Ray, and told him to clear his schedule. The emergency meeting was held in the same community room, but this time the energy was different. The president looked angry, the treasurer looked confused. The secretary was typing furiously on her laptop. Tiffany was not there. The president opened the meeting and said, "We have received a complaint from a resident regarding an attempted vehicle tow that was initiated without proper authorization. We have also been contacted by the Bend Police Department regarding a possible falsification of an HOA work order. We take these allegations very seriously, and we are conducting an internal review. In the meantime, I am suspending all enforcement actions pending a full audit of our procedures and documentation." I raised my hand. The president nodded at me. I stood up and said, "I have additional evidence that I would like to submit for the record." I pulled out the timeline Ray had created, the backdated notices, the edited photos, the petition dated before construction started, and the email where Tiffany approved my fence plan. I handed everything to the secretary. I said I am requesting that the board investigate whether there has been a pattern of retaliatory enforcement by the Rules Enforcement Chair, and I am requesting a formal written reversal of all violations issued against my property, along with a letter stating that my fence is compliant and no further info. Resciment actions will be taken. The treasurer said I move that we approve that request. The younger board member said I second. The president said all in favor. 4 hands went up. The president said the motion passes. We will issue a written reversal and a compliance letter by the end of the week. We are also placing the Rules Enforcement Chair on administrative leave pending the outcome of the internal review. If the review finds evidence of misconduct, we will take appropriate disciplinary action up to and including removal from the board. I sat down. Ray leaned over and whispered, "You just got a written reversal from management with a real citation. That is your payback." I nodded. I felt the weight lift. The president adjourned the meeting, and we walked out into the parking lot. As I reached my truck, I saw Tiffany standing by her car, staring at me from across the lot. She did not say anything. She just stood there, arms crossed, face hard. I got in my truck and drove away. The next day, I received the written reversal in the mail. It was signed by the board president, notarized, and included a formal apology for the enforcement errors. It stated that my fence was compliant with all HOA rules, that all fines and fees were rescinded, and that no further enforcement actions would be taken. It also included a separate letter stating that Tiffany Anderson had been removed from her role as Rules Enforcement Chair, and was prohibited from contacting me directly regarding any HOA matters. I read the letter twice, made 3 copies, and filed the original in my documents safe. The contractor restarted work on Monday. He finished the fence by Thursday. It looked perfect. 6 feet tall, pressure-treated pine, set back exactly 24 inches from the property line, every post level and every board flush. I stood in my backyard that evening, looking at the completed fence, and I felt something I had not felt in weeks. Peace. Quiet. Privacy. I could hear the street traffic muffled behind the boards, and I realized this was what I had been fighting for. Not just a fence, a boundary. A line that said, "This is mine, and you cannot take it from me." 2 weeks later, I heard through Ray that Tiffany had been voted off the board entirely at the next general meeting. The members had reviewed the internal audit report, found evidence of backdated notices, falsified work orders, and selective enforcement targeting multiple residents, and they had voted unanimously to remove her and refer the findings to the management company for possible legal action. The management company issued a statement saying they were freezing all enforcement actions pending a full policy rewrite, and they were offering refunds to any resident who had been fined under Tiffany's tenure and could provide documentation of improper enforcement. I also heard that a landscaping contractor who had worked in the neighborhood for years had blacklisted the Boundary Oaks HOA after discovering that Tiffany had pressured him to provide staged photos of code violations that did not exist. He posted about it on a local contractor forum, and within a week 3 other vendors pulled their contracts with the HOA. The board had to scramble to find replacement contractors, and the management company issued a public apology. Ray stopped by one evening with a 6-pack, and we sat on my back porch looking at the fence. He said, "You know what the best part is." I said, "What?" He said, "You never broke a rule. You did not vandalize anything. You did not threaten anyone. You just documented everything and made them look at their own records. That is how you beat an HOA. You make them enforce their own rules evenly." I raised my beer and said, "To documentation." He clinked his bottle against mine and said, "To documentation." A few months later, I got a letter in the mail from a law firm representing 3 other residents in Boundary Oaks. They were filing a class action complaint against the HOA management company and the former board for systematic abuse of enforcement powers, and they wanted to know if I would join as a plaintiff. I read the letter, thought about it for a day, and called the attorney. I told him I would provide my documentation as evidence, but I did not want to be a named plaintiff. I had already won my fight, and I did not need to drag it out. He understood. He thanked me for the records, and he told me the case was moving forward with or without me. 6 months after that, the case settled. The management company agreed to implement new oversight procedures, hire an independent compliance auditor, and provide refunds to any resident who had been improperly fined. Tiffany was named in the settlement as having exceeded her authority, and she was permanently barred from serving on any HOA board in Oregon. I got a check in the mail for $2,000 covering all the fees I had paid during the dispute, plus a small settlement bonus. I deposited the check, updated my fence insurance rider, and moved on. The funny thing is, about a year later, I was at a neighborhood barbecue and someone mentioned that they had run into Tiffany at a local coffee shop. She was apparently working as a real estate agent now, and she had tried to pitch them on a house in a different neighborhood. They said she spent 10 minutes talking about how important it was to choose a neighborhood with strong HOA enforcement and clear rules. The irony was not lost on anyone at the table. One of the neighbors said, "Did you tell her you live in Boundary Oaks?" The person shook their head and said I just smiled and walked away. I never saw Tiffany again after that parking lot stare-down. I heard she moved to a different part of town. The portable folding sign stand disappeared from my street about a month after she left the board, and no one ever claimed it. I assume it ended up in a storage unit somewhere, gathering dust. The fence is still standing, solid and level, doing exactly what I built it to do. And every time I walk out my back door and see those clean pine boards lined up in the sun, I think about that moment in the meeting room when I handed over the timeline and the emails and the laser-level certification, and I watched Tiffany realize she had been caught in her own paper trail. She quoted minutes, and the actual minutes contradicted her. That was the turning point. That was the moment the power shifted, and she knew it. I still keep all the documents in a file box in my garage. Every notice, every email, every photo, every receipt. I do not need them anymore, but I keep them anyway. Because documentation is how you win. Not by shouting louder, not by breaking rules. By keeping records, staying calm, and making them answer to their own words. The HOA froze enforcement pending a policy rewrite, just like the board promised. Tiffany was ordered to stop contacting me directly, just like the reversal letter said, and I got a written reversal from management with a real citation, exactly the way it was supposed to happen. Everything came full circle, and the system, broken as it was, finally worked the way it was designed to. Not because the rules were perfect, not because the board was fair, but because I made them follow their own process, one document at a time, until there was no room left to lie. I hope you got a laugh out of the chaos.